This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Okay, as promised, we're going to look at the statutory rules of interpretation, or the rules of interpretation of statute. And this is the first time, really, apart from Earl of Oxford's case, this is the first time that we're going to be looking at cases. I repeat, you do not need to know the case names, nor dates, nor facts. What is important is that you remember the principle of law that was established or confirmed by those cases. If I tell you the story, I believe the story will be more memorable than just the bald principle of law. So I will tell you the stories. Literal rule is the first of this is the big one, the literal rule. And the literal rule when interpreting statute, let me start. I mentioned at the end of last lecture, I said that the judges are sometimes faced, no matter how careful the legislature is, no matter how careful the committee stage, report stage, the debate, how carefully they review the precise wording, word by word, sentence by sentence. There are occasions when a word, a phrase, a sentence can be interpreted in more than one way. And so we have the situation where the courts, the judges, humans like you and like me, these people are having to interpret the words that are written, because the literal rule says words in a statute will be given their ordinary, everyday, literal meaning. And there's no argument, is there? Well, there may be. Where do you find the ordinary, everyday meaning of a word? And the answer is a dictionary. But which one? Which dictionary? There are so many. And so, again, it's specified. The Oxford English, the concise Oxford English Dictionary, the OED, is where you would find the meaning of a word. And so, if there is an element of dispute, the judges will get a dictionary. They already have one in court, obviously. They get a dictionary, an up-to-date one, and they'll open it and see the word, and they'll interpret it. They'll interpret that word according to the meaning of the word, according to the act. That should be straightforward, shouldn't it? Except the word set, and it's not unusual, but it's just the most extreme example. The word set has, I believe, I've never done it myself, has, I believe, 170 plus different meanings within a dictionary. If you want to take a break from your law studies, look at the word set in a dictionary, and you'll find it goes on and on and on forever. And I've never myself been able to find more than 10 or a dozen, I think, different meanings of the word set in those idle moments when I have not much else to do. So giving a word its ordinary everyday meaning can be sometimes a little bit more difficult when you're set the problem of trying to find what is the meaning of the word set, particularly if it's in a set of words. So the ordinary everyday meaning, unless, and the unless says, unless to give it that ordinary everyday meaning would lead to an absurdity. That's the golden rule. Unless the literal rule, the application of the literal rule would lead to an absurdity. And we have a couple of cases there. We've got the case Sigsworth. I'm going to break off here and I'm just explain to you why some cases are re and some cases are v. And there's another situation as well. There's also cases that begin with an R, v, somebody or other. I'll deal with the R because it's not on this page, but the re and the v are. So R is actually short. It's an abbreviation for the monarch. And if you ever see Queen Elizabeth's signature, you'll see that she signs herself Elizabeth R. And it's the abbreviation for the Latin Regina, and instead of writing Regina, she writes R. And that's accepted. And George R used to be the same, but George, of course, was not a Regina, because George was a Rex. So the abbreviation R just for both queens and kings. And Charlie, when he comes along, he will be an R, and so will William, and there'll be a lot of R's in the royal family. So that's the R. The royal family, that's R-O-Y-A-L, not R-O-Y-L-E. So the R is the Queen. It's the abbreviation for the monarch. Now, what on earth is the Queen doing taking legal action against ordinary citizens? What's the Queen doing taking action against a person called Clark is one of the cases. And Kupfer is another R case. And the answer is, well, it's not. It's such an important case, such a mind-bogglingly important case, that it's brought in the name of the monarch. And it's not the Queen or the King that is personally involved, but it is a major case. And that's why it's an R case. And it's leading, it's going to be an innovative decision. It's a pathfinding case. Re, if a case name begins with re, re is Latin again, and it means in relation to. And this one is in relation to Sigsworth, a person called Sigsworth, who is involved in a dilemma which is facing the court. So it's a problem, an issue about interpreting statute which is facing the court. And it's a case where Sigsworth, young man, wanted to go out one evening, and he said to his dad, "Can you lend me £10, Dad?" And his dad said, no. It was a farmer, canny farmer. He said, no, go and ask your mother. I lent you £10 last week, but you've not paid me back. Go and ask your mother. So he went to ask his mother. He said, Mum, can you lend me £10? I want to go out. And his mother said, go and ask your father. He said, well, I've asked him. And he said, no. And so they both sat there and said, well, sorry, but no, we're not lending you any money. So what would he do? He killed them. He just killed them and said, that's for not lending me any money. You'll not do that again, will you? So then he's facing, obviously, prison. But we have to, because these two old people, a farmer and his wife, had never left a will. They'd never left instructions, directions as to how their estate should be distributed in the event of their death, no matter how it caused. Then the administrator of the will, that's a person, the administrator of the estate. If a person is appointed by a will, then they're called an executor or a female executrix. If it's an administrator, that's been appointed because there is no will, but we need somebody to distribute the estate. And that person is an administrator or female, an administratrix. So there's these two dead people who hadn't left a will, and the administrator is now faced with the legal, because it sets out in law, the government has passed a piece of legislation called the Interstate, which means you died without leaving a will, the Interstate Estates Act of 18 blah, blah, blah. So the administrator is looking at this, and the Interstate Estates Act says that in the event of people dying interstate, then money will go to their surviving spouse. Or if they don't have one, and in their case, clearly they didn't because they were both killed, then the money will devolve down to their children. But young Sigsworth, who wanted to borrow £10, was the only child. So the whole of the estate, the whole of this farm, all this land, was going to devolve upon Sigsworth, who only wanted a tenner. He didn't want all this land and farm and responsibilities. He only wanted to borrow a tenner to go out for a drink. And the administrator said, well, that can't be right, can it? I can't pass all this land into the hands of the person who killed the parents in the first place. And so he took it. The administrator went to court. And it's a re-case asking the court's advice. What do I do? And the court looked at the Interstate Estates Act and said, words shall be interpreted according to their ordinary everyday meaning. And so the estate should pass down to the son. But that would be absurd. And so they switched on to the golden rule and said, no, we can't let that happen. That would be an absurdity. And so they would not enforce the requirement that the asset, the estate, should devolve upon the murdering son. And that was the case Sigsworth. Don't ask me what happened to the estate. If the son couldn't get it when he was released from prison, don't ask me who did get it, because I don't know. If it had been in Cornwall, I do know that if a person dies intestate in Cornwall and no surviving relatives can be found, then the estate will pass to the Duchy of Cornwall, and the Duke of Cornwall is, of course, Prince Charles. So Prince Charles would get it. So it's worthwhile leaving a will, if only to stop Prince Charles and Lady Camilla, the Duchess of Cornwall, from inheriting your wealth. Get yourself a will, and that will prevent any possibility. Whiteley Chapel, I like Whiteley Chapel. Whiteley Chapel establishes again, unless it would lead to an absurdity. And this is about two old men, neighbours, both widowers, living next door to each other in their little bungalows. And they would visit each other, and the door was always open for them to go in and have a drink and a jar and chat, a cup of tea or coffee, and read the newspapers together. And they'd talk about world affairs, they'd talk about home affairs in Britain, about what the Prime Minister was up to. And finance they'd discussed politics and sport. And a general election was coming up, and they discussed which way you're going to vote. And they discussed it and talked about it and decided, and both of them decided they were going to vote Conservative. And on the morning of the election, one went round to his neighbour and knocked on his door, and there was no reply. So he went in, and there's his neighbour, dead, sitting in his chair by the fireplace. The fire had gone out, and television was still on, and he just died in his sleep in his chair. So he went to the neighbour, not the dead one, the neighbour went to the polling station and voted. And came back, and he's thinking to himself later, he's seen his dead friend being taken away to the funeral parlour, and he thought, it's a shame that, because I know the way that he was going to vote, and he's wasted now. I'll go and vote for him. So he went along and registered as his neighbour and voted for his neighbour. I don't know how, but it was discovered that this dead man had apparently voted. No, I have no idea how it was discovered, but it was discovered. And so the neighbour who had done the voting for his dead neighbour, for his dead friend, was taken to court and prosecuted. This is a criminal offence, misrepresentation of the People's Act. And he was prosecuted, and the defence counsel raised a defence and said, it says within the misrepresentation of the People's Act that it is a crime to represent yourself as someone else entitled to vote. And I put it to your honour that my client did not represent himself as someone else entitled to vote. He represented himself as a dead person, and dead persons are not entitled to vote. And the court was faced with this literal interpretation of the misrepresentation of the People's Act, and they said, well, strictly, the defence is right, but that's absurd. That goes completely against the reason why the Act was passed. And so, because it was an absurdity, they applied the golden rule. So the literal rule will be applied. Words will be given their ordinary everyday meaning, unless to do so would lead to an absurdity. The third rule is the mischief rule. This is what the statute is trying to control. The case Gardner and Sevenoaks was about the storage of film in premises secure from fire. And the man who was storing the film, lots of film, reel upon reel of film, was storing it in a cave. And the local council said, you're not storing it in premises secure from fire. He said, I am. The premises secure from fire. They said it's not a premise. And he was taken to court, prosecuted. And the court had to look and say, well, premises are normally places where work is carried out, or people live, or temporarily reside, or meet. And caves don't really fit into the heading of premises. But the mischief, the reason why the Cinematographs Act was passed, was to restrict the fire hazard. And caves are not known for their spontaneous combustibility. There's not really, and even if they do catch fire, where's the danger? It's not like some tower block in London that would get swallowed up. It's not like Towering Inferno, the film. It's premises secure from fire. Surely a cave is a location secure from fire. So for the purposes of the Act, so for purposes of the case, the judges interpreted the word premise as including caves for the purposes of this particular storage of film situation. Gorison Scott, sheep being transported by a ship, in the older sailing ship, and sheep had to be kept in pens of no more than 10 sheep to a pen, and they were all the way across the decking of the ship in order to prevent the spread of disease, because if you let the sheep wander around freely, then they're going to, if one is diseased, they will spread that disease amongst the whole flock. Whereas if you restrict them to 10 a pen, then only 10 at most are going to die. So that's what happened. They restricted them, or rather they didn't. They didn't restrict them, they let the sheep wander. And along comes a wave and sweeps the sheep into the sea. And of course, sheep with a woolly coat can't swim. They're not notable swimmers. They're not Mark Spitz or some Olympic swimmer. And they drown, the sheep drown. And it was discovered that there were no pens on deck. They'd not been swept away, there were just no pens. They never had been there. And what was the reason for the pens? Was it so that if a big wave came along, the sheep wouldn't be washed over? Or was it to prevent the spread of disease? And the answer was it's to prevent the spread of disease. That was the mischief. It was to prevent the spread of disease. And even if there had been pens, a wave comes along, takes the pens with them. So the mischief rule was applied. What was the mischief that caused that piece of legislation to be passed? Eius dem generis is Latin, I'm sorry. Eius dem generis, things of the same class. If you talk about dogs, cats, and other animals, when you have specific words followed by general words, you can only include into the general category things of the same nature as the specifics. So dogs, cats, and other animals, we're talking about domestic pets and other domestic pets. Now, some people keep snakes and rats as their domestic pets. Well, fine, okay. Some people keep tarantulas as domestic pets, but they're not really responsive. You don't straight a tarantula and say, oh, what a good spider you are. So we're looking really at this narrower version of domestic pets. And you wouldn't include, for instance, a snail in there, or a tiger. So cats, dogs, cats, and other animals, yes, all right, a tiger's a big cat, but it's not clear enough to become within the category of small, let me put it that way, small household domestic pets. So Evans and Cross was about a car that came to a crossroads. It came to the crossroads and there's a stop sign, a halt sign, not a stop sign, a halt, which is written on the road. And he didn't. He went straight over. He didn't stop at this main road. He just carried straight on over. And there's a police car there. And he saw this car drive straight across. And the police car chased him. And he was prosecuted for failure to obey the Road Traffic Act. And the Road Traffic Act said that motorists will obey roads, signposts, finger posts, indication posts, and other indications. Well, signposts are above the ground, and finger posts are above the ground, and direction posts are above the ground, but halt was written on the road, and so it was not of the same class. It was not an above the road visible, sticking up in the air sign indicator, and therefore he escaped. But it wouldn't happen again now because the law has subsequently been changed. So whether they be in the air or on the road, you still have to obey those road signs. Expressio unius est exclusio ulterius. If it had said you must obey signposts and fingerposts, but it didn't mention direction posts, then to express something is to exclude the others. If you don't put those general words and other signs, then you're excluding them. You will obey signposts and fingerposts, but you don't have to obey anything else because it's not indicated. So the expressiones, Latin again, but you can work out what this says, can't you? Expression of unius one thing, est is universal, is exclusion of the alternatives. And you can see that expressiones est exclusio ulterioris is almost a literal word-for-word translation. The expression of one is the exclusion of others. Nosciter asochis, you can work out the meaning of a word from the context in which it is placed. And nosciter asochis, the meaning nosciter asochis is social neighbours. And you can derive the meaning simply from the positioning of the word and the context in which that word is written. In pari materia, where we have, I've mentioned already in 2 lectures so far, the Judicature Acts of 1873 to 75. If there were a dispute about a word, the meaning of a word in the 1873 Judicature Act, then that interpretation of that word in the 73 Act shall be equally applied to similar, in pari, same material, it shall be equally applied to that same word in later Judicature Acts of 74 and 75. The purpose of approach, for example, civil partnerships, are trying to find what is the sensible purpose. We talked about in legislation before LGBT, we talked about husbands and wives. But now if we have same-sex marriages or same-sex relationships, not even in a marriage relationship, same-sex relationships, or even hetero relationships where the man and the woman are not officially married and they're therefore husband and wife. The purpose of approach says, for the purposes of legislation, the woman with whom I live but who is not my wife, okay, a common law wife, but she may not have served enough time to be classed as common law. If we were living together, then for the purposes of interpreting statute, she shall be treated as my wife, I shall be treated as her husband. So that's the purpose of approach. And we can't interpret statute which would lead to conflict. I don't know. I don't know whether that's going to apply or not. Comes Brexit. I don't know whether we're going to be bound by European law or not. You can't interpret statute which would be in conflict with Europe. Maybe you can after Brexit kicks in.